Well, I guess we'll go ahead and start since, right? Yeah? All right. Well, my name is Agustin Barbara. I am a crypto attorney. My firm is literally the Crypto Lawyers. We're headquartered out of Miami. My background is in intellectual property. I am a US registered patent attorney, so I help projects literally from ideas to launch, copyrights, trademarks, trade secrets, intellectual property, licensing, and so forth.
Hi, my name is Charles Slamowitz. I'm an attorney based in New York. I've been practicing for 6 years, and I've been counseling over 35 NFT crypto projects over the past year. And I've done a program at Stanford. I've sold my own businesses before. And my entire goal in this operation for Web3 was really to try to understand what's happening in the law and counsel my clients to the best of the ability since it's ever changing.
Hey everyone, I'm Jorge Franco. My background, I'm an attorney as well here in New York City. My background, excuse me, is predominantly in intellectual property. At one point I started my own business as well, dealt with intellectual property matters there, licensing rights with Olympic athletes, traveled around the nation, you know, to assist with that. And yeah, just here just solely to speak in regards to that.
Hi guys, my name is Rami, Alameh in Web 2, Achilles in Web 3. I'm an ex-lawyer, so I studied law, went through corporate, legal, worked at a major firm in downtown Manhattan, then decided to leave everything, focused on cryptocurrency, NFTs, blockchain, so I went deep into what some people call degen culture. Started my own legal tech startup, got funded by 500 startups, Y Combinator. Basically, we launched in Abu Dhabi a legal tech startup that focuses on AI for legal, and we're a big team now in Abu Dhabi, over 25 people working on AI for legal, and I'm an avid Twitter user and NFT buyer and trader and stuff like that. So I'm going to be talking about that, how IP influences this and how it impacts all of this, these collections that you see out there.
Just to get a baseline, how many people here are lawyers? Okay, so we can, how many people here are looking in, or launching a project or have launched a project and are kind of looking into the legalities of it? Right. So it's a good setup. So, I mean, there's tons to talk about, so we'll kind of address sort of the most common questions that we tend to see. And I guess I'll start. One of them is the commercialization of your NFTs. Right, so I have a lot of clients that there's really two schools of thought. There's the Bored Ape, right, sort of theory, if you will, that you give your NFT holders the entire commercialization of the IP. Right, they can do whatever they want with it. That's one extreme. Then there is the other side, which is you're very aggressive in protecting your IP, where you can essentially own the NFT so long as you're not doing any derivatives or anything of that nature. Well, there's no right or wrong answer. It really just comes down to what's your goal? What do you want to do with it? I think to put yourself in a category such as, you know, Bored Ape or Mutant Ape, you know, it's, they're kind of an overnight sensation, but you really have to think long term. And that's something that, you know, we were talking about.
Right, we discussed this as well. And so to me, I think it boils really down to 3 points right now, if you look at it from a legal perspective. And that is authenticity, control, and community. And with respect to authenticity, for the first time ever, we're living in a world where we could now verify, decentralized. We have a blockchain. And this is a new technology, and this is not going away. We don't know exactly how it's going to be. We don't know exactly how NFTs will be. But the underlying blockchain will still be there. The fact that you can now verify an artist or somebody else is novel, and it's something new that the legal courts are still grappling with. Some are trying to say, oh, it's same old, it's the same thing, but we know that there are some differences, especially with the cultures that are developing. So with the authenticity, you always want to verify and say, who actually is this artist? Are they who they say they are? And anybody else involved, such as a collaboration, you also want to verify them as well. Just because they're verified on the chain, you still kind of have to do the diligence that way. And what we noticed about control, and what Agustin and I were talking about, is the artists now have a unique position. And as an attorney, you have a responsibility to inform your client and say, you could either give away all of your IP, which is typically not done, but we've seen projects be massively successful and go gangbusters, such as Bored Apes, by giving away a lot of IP, because Web3 is more community-based than competitive. And at the same time, the artist could decide what to assign. The artist could assign a physical art piece with the NFT, an audio file. The artist could assign some rights, and some unique cases I've worked with clients where we assign rights to the holders, but then we say if the holder violates the community guidelines, we've said in the smart contract that it could be frozen, transferred, or otherwise. And just finally, the community, and we're going to talk about this a lot today, because in a legal perspective, we're very keen, and you have to protect the client first. We also have to realize that the client may ultimately become the community. DAOs are one of the new emerging structures for Web3, and a lot of people starting out in NFTs, they may ultimately have their community and holders join a DAO, a community with different guidelines, and we'll get more into that.
Well, another thing that's worth mentioning is, as an attorney, who are you representing? Are you representing the artist? Are you representing the company? Are you representing the general public? So that's something important. Why? Well, if I'm representing the artist, I want to make sure that the artist himself retains the copyrights, okay? We'll have royalties. If I'm representing the company, right, I want the artist to grant all right, title, and interest to the company with whether it be a flat fee or royalty. So it really comes down to through what lens are you looking at. And again, if you want to go the Bored Ape route, well, what's going to be your revenue, right? Because once it sells, aside from royalties, what else do you have to offer? Because at the end of the day, NFTs, this is a business. And you have to have the infrastructure and sustainability to maintain the ongoing R&D and making sure that the platform is running adequately and making your community grow, right? That's what everybody wants, essentially.
Just want to say something. Just to shift a bit, because I come from a startup background. At the end of the day, as you were saying, you ended your sentence by saying it's a business. And effectively, what we're seeing in the NFT space at this stage and at the early stage that started with VFriends last year is a lot of projects started off, created a hype, created a community that joined certain memes and certain exciting aspects of a certain project. Could be the art, could be the vibe, could be just throwing out certain memes on Twitter, could be anything. And they did not really understand the depth of creating value. And that's where the problem lied, and that's, I think, where the valuations are a bit off to what they should be, because they're not connected to the real value of the things that are being produced. And here, there are two arguments. First argument is, are we creating that value through just the pure revenue that is made from this project, which would basically translate into the value of the asset that you are holding, be it Bored Ape, Azuki, whatever NFT you are holding, or is it the actual access to the experience that you are actually getting from this token that you're holding? And in both cases, the value applies. It's about the quantification of this value that the question arises. And if you are launching your NFT project right now or thinking about launching one, the first thing you have to think about is this: what am I doing in creating that value? Am I creating that value purely by generating certain revenues? And it's not only royalties. Revenue has to come from a revenue stream that is different than royalties. Or are you creating a certain experience that is so exclusive that people would want to pay a premium to get access to? These are questions you should ask yourself when launching your NFT project, I think.
And I think Rami is absolutely right in terms of that lawyers really need to reframe their focus. Web3 is a lot more about collaboration than it is about competition. If you look at spanning from back to the Industrial Revolution, we're seeing such a major shift here, where a lot of the courts, even the Southern District of New York, the FBI, there are certain cases where you could say it's wire fraud, you could say that certain rules apply, like insider trading, but the development of the community is completely different. Even as an attorney, I was privileged to work on a documentary about women in Web3. I was able to produce it since I have a lot of large women in the space who span throughout Web3. It's projects like these where you could collaborate with the community and you have to be open to it to realize. So when you set up a company, as Rami was saying, and what that we've realized is, you don't always know where the company is going to go. If you create a DAO structure, you may think about a mission for the community. You may think about, is the DAO ever going to end? I've counseled the Constitution DAO. I understand what's going on there, but at the same time, it's still like an amorphous area. So there's just a lot to consider.
So true. I think also you hit a really good point, and you were talking about value. And this is where the keyword utility comes in. But I don't necessarily have the answer for this, but utility. Is utility one thing and then benefits something else? Because if you're going to say that your NFT has utility because you're allowed to, get a burger and attend a free concert, well, I don't know if I consider that utility. I consider that a benefit.
I mean, yeah, but if you look at for example, the VFriends collection, right? The people who joined the V1, I was one of them. We joined because it was an access to Gary Vee. That was the goal. We wanted to. There were tokens that would give you an exclusive access to a podcast with him. That would give you access to an exclusive meetup in a certain place with Gary Vee and the team. So these things we considered as valuable when we joined. So at the end of the day,
and I agree. But is that utility?
That's a good question. I agree.
Right now, it's litigated the Nike StockX case, where StockX is basically saying, they were selling some Nike shoes. It's more of a counterfeit issue, obviously, but at the same time, in the initial complaints, they said, NFTs don't have any inherent utility. I'd argue and say we're still developing here. We're still creating layers. They may. The courts may not agree with that because the courts may not know. But we're still kind of staying tuned to see what happens. And it's developed in a way, some of the shoes are now coming out as they may be counterfeit. So it may give us some guidance as to counterfeit goods. But this is one of the few cases. We're also looking at Hermes right now, which is happening with Rothschild. And we're saying, okay, is a Meta Birkin, is a Birkin bag without Hermes permission okay? Is it not? Depending on the filing, you could go different trademark filings, for instance, like 952, like advertising, computer technology. It depends on the structuring, and we're really going through a shift. I also did want to include George a little bit more to talk about it.
Yeah, no, thank you. So I guess, just kind of piggybacking what everyone was saying earlier in regards to utility, the functionality of these NFTs and whatnot, that's all fine and dandy. But the matter that, I guess, in forewarning the legal landscape moving forward, though, in regards to jurisdiction, and whether or not should some commercial transaction go awry, or should some complication arise, then the question is generally presented, do we have the authority to pursue any sort of legal action? Usually we look to the international courts because, as we know with the Web3, essentially everything is shrunk. Just nowadays, I could go and purchase X, Y, and Z from somebody in India or from somebody in North Korea. And so then the question presents, hey, ultimately, is it within the realm of possibility to seek a remedy? And so the courts generally look to three tests. one being whether or not they have the prescriptive authority to do so. So we see that for the contract for the international sale of goods back in the 1970s, which just kind of said, hey, ultimately, whether a goods or service was able to be litigated in the courtrooms internationally. And so any country who signed on to that sort of had jurisdiction. But then we look to the second test as to whether or not there's adjudicative power, whether or not the courts could hear that. And so, that's done with personal jurisdiction and whatnot. And lastly, the third test is whether or not the country has the enforcement capabilities. Who is it to say, that somebody in India or China or, X, Y, and Z country, that we have the authority to enforce, our rights over them?
Exactly. We were talking about this now. So through NFT.NYC, I'm learning about new developments that are happening, arguments between big firms. One of them being, okay, there's some sort of copyright ripoff or there's a knockoff, but you can't prove necessarily that it's subject to US jurisdiction. You can't prove it's a free trade zone right now. So sometimes, depending on the circumstances, it opens up different issues about actual jurisdiction.
And so, at least from a domestic level here, right, in the States, what do we have to protect, right? And so there's a couple of tools that we can use. One of them being, right, we have the DMCA, the Digital Millennium Copyright Act. So one thing that's always important is if you are using an artist, okay, that you are essentially having them commission a series of, I don't know, I would say something weird, but I don't know, wolves, or tigers, lions with different little hats and so forth. Well, you want to make sure that you're indemnified, right? Because what if this artist that you're counting on, right, they're actually ripping off the work of somebody from Switzerland? If you don't have a DMCA policy in place, they can essentially take your site down, right? So that's one. So you want to make sure that the artist is indemnifying you as well. There's also the trademark route. So you have trademark protection. Trademark protection is not necessarily for you, right, the company, but rather the consumer, right? So you know that when you're getting X company, right, you associate the brand, the goodwill, you know that it's quality and not just some sort of rip-off or fake. And then there's also the patent component, which, again, you'll see here and there, but when it comes to patents, it really has to be a little bit more developed. It's a very competitive space, and then you have the technology aspect, which is very in-depth. But
yeah, and even when you're looking at intellectual property, you have to take more of an empirical approach, because counseling all these clients made me realize there were considerations that you may never think of. I've had 3 or 4 co-founder agreements go awry because there was a hacking when the launch was released, which no one really thought would happen. Discord was spammed with bots. There were people who recorded all their meetings on Zoom. Different things, and these are, spin-offs of Fortune 500 companies. Things that are happening here that you wouldn't anticipate. And what I've also noticed is the terms of use. When I was back in Emory Law School, 2013, my internet professor said, he taught me internet law. He said he never reads the terms and conditions. He knows he wants his iPhone, he wants to download his app. What's the point in reading them? But I see Web3 changing. I think it's so important you must read the terms and conditions. As a lawyer, you must craft them appropriately, because they're going to be integrated into a smart contract. Something unique that I haven't seen other lawyers do is creating those guidelines and saying, if I'm going to give away some of my NFTs, don't do something obscene with them. Don't use it for pornography, any polarizing political views. A lot of different investors and a lot of different artists and projects have reputations at stake. We see a couple blue chip artists, Damien Hirst, for instance, Banksy, the usual suspects, but you really want artists to feel comfortable and know that if I'm going to go into the space, it could be used in the way that I envision. It could be a broad thing, but these are the terms of use, and these are getting redefined.
And that's a great point. And you have to remember that the consumer is, there's a wide spectrum here, from the sophisticated to the ones that are just beginning to dabble with it, that are still using credit cards to buy for their NFTs. But what's important, and I'll give you just the most basic one, is I have, when I draft terms of use, I specifically have areas that are just bold and red. Why? So you are running on the ERC 721, right? So your NFTs are minted. However, in this scenario, you're going to be using Cardano blockchain, right? So I buy your ERC 721 or vice versa, and I send it to the wrong wallet. Well, now who's on the hook? If you didn't explicitly state that, right, that's one issue that they'll come and start making trouble for you. There's no ironclad mechanism, right, that will make you immune to any sort of lawsuit. What we're doing here is we're building a house and a moat and an alarm system and guard dogs and just making it very difficult, right, for it to be penetrated. Is it possible? Sure, it's always possible. However, we make it very, very difficult depending on what you're looking at.
Yeah, and just in the prior discussion, and then I'll let Rami go, was right now we're looking kind of backwards in a way. With nodes in the blockchain, sometimes it's very hard to change something. Obviously, ERC 1152 is getting better, and we're able to now create fungible tokens, non-fungible tokens on the same chain. We're able to change things a little bit with terms of use and looking back. But at the same time, we have to realize as lawyers and as clients as well, the technology is constantly evolving. So if you're going to have something subject to change, it may be better to have, if you were to create a DAO, for instance, which I'm very keen on. I'm speaking in Germany in October at a DAO Castle because Europe is also looking at DAOs very closely. I think that it's super important to have a community vote, understanding that things are ultimately going to change. But we have to work with the technology that we have.
I just want to add one thing, because I think we touched on the local side, but on a more international side, which is specifically for the UAE, where I'm mainly based, there's a new regulatory agency that was created called VARA, the Virtual Assets Regulatory Authority, that is being very proactive in actually dealing with these kinds of issues and in these and with everything related to intellectual property related to NFT projects. So regulators are actually moving in on this, especially in countries, for example, like the UAE, who is really keen on developing this. So I just want to say that when you are launching this NFT project of yours, and I'm talking from a more kind of not practical, but I mean more business-oriented side, not very legal, still you need those agreements, because one of the routes that you could go in your NFT project is the VC route and the investors route. So therefore, you could potentially raise capital other than the NFTs that you're going to sell from investors on the company that you're going to create, and therefore give equity in this or anything in the DAO or anything else. So this is very important for you to organize. And as Augusto and Charles said, and Jorge, basically you need to really organize all of those legal documents in one place and organize everything.
Yeah, and DAOs are so new, right?
Exactly.
So I've created for investors, there are so many issues where investors say, we really like the project, we believe in the mission, but what's going to happen if the DAO fails? We can't really control our capital. We're not A16, we can't just run on data. I've created DAO Lights, which means that you could have some aspects of a DAO, but then you could structure it and have 2 or 3 different advisory companies. And 4 board of advisors have already voted, and it's very new. But we're going to see how that goes, because I think there are ways to work with the community, work with Web3, Wyoming, hopefully other states work with us as well. And that's really how the law has been developing, so stay tuned.
Hey, thanks, guys. This is really amazing. Unfortunately, we don't have time for questions, but you guys will be available outside?
Yeah,
I'll be
outside.
around? Okay, beautiful.
Thanks.
Yeah, thank you.
Thank you so much. Better to go off that side.